está in the financing. Okay. Session 4, Introduction and Definition of Concepts and Background, Benefits of Conditions, Payment of Price, Difference between Salam and Murabaha, Delivery of Goods, Options available with purchaser after delivery, Revoking Salam Contract, Scope, Benefits, and Economic Importance of Salam. Okay, Salam as an introduction, the basic conditions for the validity of a sale in Sharia are 3. The purchased commodity must be existing. The seller should have acquired the ownership of the commodity, and the commodity must be in the physical or constructive possession of the seller. There are 2 main exceptions to these principles in Sharia, and that is Salam and Istimna. Seller agrees to supply specific goods to the buyer at a future date in exchange for an advance price fully paid at spot. For the Salam, price is in cash, but the supply of goods is deferred. Background of Salam. Before Prohibition, the farmers used to get interest-based loans for growing crops and harvesting. After prohibition of interest, they were allowed to do Salam transactions. This helped them to get money in advance for their needs. During the days of the Prophet ﷺ, the caravans used to get the interest-based loans for purchasing the commodities. After prohibition of interest, they were allowed to do Salam transactions. The purpose of Salam is to meet the needs of small farmers who need money to grow their crops and to feed their family up to the time of harvest. To meet the need of working capital, to meet the needs of liquidity problems, and to meet the need of traders for import and export business. Salam is beneficial to the seller because he receives the price in advance, and is beneficial to the buyer also because normally the price in Salam used to be lower than the price for spot sales. It is necessary for the validity of Salam that the buyer pays the price in full at the seller at the time of effecting the sale, because the basic wisdom of allowing Salam is to fulfill the instant need of the seller. If it is not paid in full, the basic purpose will be not achieved. The only goods can be sold through a Salam contract in which the quantity and quality can be exactly specified. Precious stones cannot be sold on this basis of Salam because each stone differ in quality, size, weight, and their exact specification is not possible. All details in respect to quality of goods sold must be expressly specified, leaving no ambiguity which may lead to a dispute. It is necessary that the quantity and the commodity is agreed upon absolute terms. Salam cannot be affected on a particular commodity or on a product of a particular field or farm. Supply of wheat of a particular field for the fruit of the particular tree, since the possibility of the crop is destroyed before delivery. Given such possibility, the delivery remains uncertain, which kind of connects it to Garar. The exact date and place of delivery must be specified in the contract. Salam cannot be affected in respect of things which must be delivered at spot. Salam, wheat and barley, between wheat and barley. For example, the commodity of Salam contract should remain in the market right from day of contract up to the date of delivery, or at least at the date of delivery. There should be actual delivery of commodity. Payment of price, Salam capital. Price is stipulated. Forms of legal tender, coins or notes. Usufructs of assets can also qualify as Salam capital as long as they don't amount to riba or usury. The buyer of the Salam should be advance the whole price of the commodity at the time of the contract agreement. The transactions involving barter, exchange, the number of quantity does not matter, do not qualify as advance for future delivery of similar goods. A bank cannot advance wheat for showing against exchange for 5 tons of wheat at harvest. Difference between salam and murabaha sales is common differences. The in salam purchased goods are deferred prices paid on spot, whereas in murabaha purchased goods and deliver on spot price may be either on spot or deferred in installments. In salam, price has to be paid in full in advance. Murabaha price may be on spot or deferred. Salam is not executed in particular commodity, but commodity is specified by specifications, and murabaha can be executed in particular commodity. Salam cannot be effected in respect of things which must be delivered at spot. Salam between wheat and barley, for example. Murabaha can be executed in those things, though. Difference between, furthermore, before delivery, goods will remain at the risk of the seller. After delivery, risk will be transferred to the purchaser. Possession of goods can be physical or constructive. In transferring of risk and authority of use and utilization, consumption are the basic ingredients of constructive possession. Available for purchaser after taking delivery is a parallel salam. After the execution of salam agreement with one party, buyer or seller executes another salam agreement with a third party. Conditions of parallel salam are that there must be two different and independent contracts. These two contracts cannot be tied up, and performance of one should not be contingent on the other. Parallel salam is allowed with third party only. First salam seller is salam sale, delivery of commodity to the Islamic bank purchaser. For salam seller, parallel salam to delivery commodity to an Islamic bank seller. Agency agreement. If the bank has no expertise to sell the commodities received under salam contract, then the bank can appoint the customer as its agent to sell the commodity in the market. Third party subject to salam agreement and agency agreement are separate from each other. Price must be determined in agency agreement on which the agent will sell the commodity, but if the price is increased, the benefit can be given to the agent. If the bank has expertise in the relevant commodity, it can sell the commodity in the market third party or hold the commodity to fetch a better market price to maximize its profit later. Before maturity, bank can take promise to purchase from a third party. After taking delivery, bank will sell the same commodity to the promisee, and he will be bound to the purchase the same according to his undertaking. This promise should be unilateral. Salam combining with murabaha, the two bank can sell salam commodity to the seller of salam on murabaha subject to following terms. Salam agreement and murabaha agreement should be independent, not contingent, or with free will of the parties. Murabaha will be executed after taking the possession of salam goods. Bank shall assume the risk of loss between taking delivery and execution of murabaha. Bank can take undertaking from seller of salam that he will purchase the salam commodity from bank on murabaha basis. After execution of salam agreement, it cannot be revoked unilaterally without mutual consent of both parties. Seller can undertake in the salam agreement that in case of late delivery of salam goods, he shall pay the charity account maintained by the bank a sum calculated on the basis of a percentage annum for each day of default. Bank will spend this amount in charity purpose on behalf of the client. The undertaking is in fact a sort of Yemen Nazir, which is a self-imposed penalty to keep oneself away from default. A security in the form of a guarantee, mortgage, or hypothecation may be required for salam in order to ensure that the seller shall deliver the commodity on the agreed date. In the case of default in delivery, the guarantor may be asked to deliver the same commodity, and if there is a mortgage, the buyer can sell the mortgaged property and the sale proceeds can be used either to realize a required commodity by purchasing it from the market or to recover a price advanced. The salam sale has flexibility to cover needs of various sectors: farmers, industrials, contractors, exporters, traders, capital requirements, as well as meet the cost of operations. Sustainable finance and agricultural operations deliver in cases the crops fail. Thus, the bank renders great services to the farmers in their way to achieve the production targets. Production of export commodities and the purchasing of it on salam, marketing them to lucrative prices. Craftsmen and small producers applies the salam sale to supplying with the inputs of production on salam capital in exchange of some commodities in the market. And it's good for the seller, it's good for the purchaser, it's good for the producers. The buyer's point of view. Okay. Istisna, order to manufacture. Financing. Concept, legality, definitions, features, workflows, to financing concept. Similar to salam's law, sale takes effects before delivery of goods. Legality, accepted by Sharia. Large infrastructural projects and required manufacturing, buildings, ships, airplanes, etc. Based on public interest. Istihsan. Definition: agreement in the result of sale agreement whereby purchaser places an order to manufacture, assemble, construct anything delivered at a future date. Nature of contract is sufficient to cover both the initial agreement and after manufacture. Different from the MPO. Istina is widely used to finance projects like housing, building of bridges, roads, highways. Price is usually fixed, mutual consent. Manufacturer's obligations. The manufacturer is responsible for providing raw materials and labor. They're supposed to supply goods according to agreed terms. Buyer's obligation is the buyer is obliged to accept goods according to the agreed terms, type, amount, quality, that sort of thing. Parties may agree on a certain period, which makes a manufacturer responsible for the defect of the manufactured item before delivery. Subject matters of Istina valid for only goods that have to be manufactured or constructed. The seller does not have to be the manufacturer himself. The object must be clearly defined. Readily made natural goods or items are excluded. Examples: animals, fruits, etc. Homogeneous, unique goods or items are valid istisnas, contracts based on agreement. Contract is binding according to specifications. Seller is only required to supply the goods and specify the agreement except otherwise. Some contracts require the seller to actually manufacture the item of it. Ready-made assets cannot be sold through istinas. Bank cannot enter istina contract with a car dealer who has the car in his possession at the time of istinas. Some issues need to be cleared here. The problem is not with the availability of the item, but that it should not be specified at the time of istina. Any other object that have been produced can become subject to matters. Real estate, construction, buildings sold according to specifications. Islamic banks can serve both manufacturers, sellers, and istina. Price is istina. Price can be in different forms: cash or any tangible goods or surplus. Government enter the istina contracts, build, operate, transfer, BOT. Price once settled cannot be unilaterally increased or decreased. Contingencies and changes in price of input must be considered. Late delivery of item may attract penalty. Not permissible to draw penalty clause for purchase for default amount in riba. Voluntary rebate is possible based on agreement. After an order have been placed, manufacturer should honor the terms of devoting his time to the contract. However, penalty is only permissible if the delay does not result from force majeure, intervening contingencies. Binding nature is contract. Non-binding before manufacturers start work. Before work commences, any parties may cancel the contract, but not after the contract has started. The purchaser have right to defect, but not inspection. Some banks, two options: enter into istina contracts, either a manufacturer or purchaser. Depending on the nature of their role, they can give demand, security, collateral, performance bond, and ensure the terms are respected. Arbun can be taken as a foreign down payment or forfeited in case of breach in contract. Assuming that the contracted party is not able to manufacture the item, he may subcontract another to do the job. Silent contract. The bank enters into contract with customer and another with the manufacturer. Okay. Parties agree on who will bear the supervision expenses. Two contracts should be independent of each other. Work in progress. After when work has started, the contract cannot be rescinded unilaterally. As stipulated in the agreement, supplier will supply according to the specification of manufacturer, will pay according to the agreed price. Bank, as the purchaser, bears risk associated with holding manufactured upon delivery. This include tackle and maintenance, which is insurance on theft or abnormal damage. For the most part, difference between Salam and Istana. In Salam, the price is paid in advance, while in Istana, it may be paid in cash or by installment. This has a lot to do with the nature of agricultural production. When most activities took place in the planting stage, it is important to release all capital during the critical stage, after which less capital is required. In contrast, Istisna production, unlike Salam, deals with production in stages, all of which require capital injection. The time of delivery is the essential part of the sale of Salam, while it's not necessary in Istinas that the time delivery be fixed. Lastly, the contract of Salam, once effected, cannot be cancelled unilaterally, while the contract of Istisna can be cancelled before the manufacturers begin work. Leave questions in the comments. Rate, comment, subscribe.